Okay, so this is actually take 4 of Looney on plagiarism. 7 different kinds of plagiarism, which is interesting because he has 8 accounts in the paper, but one of them was deemed to actually not even qualify as plagiarism, so perhaps that's why. I figured we'd start by accurately defining plagiarism. It's a little bit different from copyright infringement. Plagiarism is the duplication of ideas, processes, or words without credit. The without credit part is kind of where it gets, I think, a little confused with copyright law. You are able to quote out someone else's ideas in their exact words as long as they are cited for that. You also do have to cite the idea to avoid plagiarism, and that's kind of where it deviates from simple copyright. It's also a little bit less legal and a little bit legally bound and a little bit more board regulated. It has more to do with your university and with the scientific community rather than with the publishing community. If, for instance, something is common knowledge, the text used the example of Darwin's evolutionary theory. That is such common knowledge at this point that it no longer needs to be accredited to Darwin. It's kind of a given that that's who did that. Why is this relevant? It's relevant to the public because what you're actually doing when you're contributing an article to a scientific journal is adding to what is essentially a historical record, and being able to backtrack along that historical record gives the community, both the scientific community and the public community, should they be so interested, the opportunity to access that data, what is essentially a data trail. And if you plagiarize, what you're doing is either falsely representing or in some way occluding that data trail so that it can't be properly traced back. It's important to the scientists for obvious reasons. Your university is going to have a very every university has a standard of misconduct, and the university review board that's going to follow up on accusations of misconduct. Now, that definition of misconduct has been adjusted. It's fabrication, falsification, or plagiarism. The new definition does omit intent. It doesn't matter whether or not you intended to plagiarize the information. It matters whether or not you actually did it. Intent has become much less important. It varies from copyright to citation. If you can cite something and still be plagiarizing it. If your work contains no original material, if it's not properly cited, etc., then it can still be plagiarism, and that would make it fall under misconduct. A misconduct review is a very standardized, very sort of professional thing that takes place. It has certain important obligations to the people that are involved. It is supposed to be prompt, confidential, and effective. The initiator and the respondent both have certain rights and certain protections, and these are important because what we're talking about is both a body of knowledge, which is the history of the scientific community that we're talking about, and also careers that are involved. Being published, doing the research, those are things that contribute to the life cycle of a particular thought process and therefore a particular career in a scientist's life. There are 2 portions. It doesn't always even reach the second portion, which is investigation. There's inquiry and there's investigation. Inquiry is basically looking to see if you have the grounds for should we even bother checking into this as it's actually potentially plagiarism. The investigation is the more formal part. It's necessary that it be clear, convincing, have a time limit, and have a specific administrator assigned to it. Possible outcomes are sometimes something as complex as personal prohibitions. You can end a career. You can make it so that people are not allowed to sit on a board due to the level of their misconduct. They aren't allowed to serve in certain capacities. They can have sanctions imposed against them, and as grants are the lifeblood of scientific research, that's going to dead end your research career very quickly. Most of the time, from the evidence or from the incidences that I saw in Louis' articles, it's more along the lines of an apology. Very often these things are settled outside of any sort of major career-ending sort of sanctions or personal prohibitions. Occasionally the article is retracted. In our weekly discussion question this week, they did definitely point out an instance where the article was from, it looks like most people's point of view should have been retracted completely. Very often they are settled with an apology, and possibly also something along the lines of an addenda where it's clarified, that in the journal or etc. that certain credit should have been given here and it was not. The 8 cases that Louis covers begin with one in which the parties submitted another's work. They submitted it to an employer. The employer had required that they be aware of this sort of, be familiar with this sort of work in order to get the job that they were trying to get. And it wasn't considered a major instance of plagiarism. As I mentioned before, the focus on the plagiarism is that the public domain be protected, and the plagiarism didn't enter the public domain. The man or woman was never compensated. They didn't get the job, and then also the plagiarism never entered the public domain. So in this particular case, an apology was deemed to be all that was necessary, and they kind of moved on from there. So the translation with citation was the next instance, and that's very interesting because it's something that's covered internationally. There is something called the Berne Convention that covers what rights you have when you translate a piece. What happened was an author went to a text that had been existent about several hundred years prior, I think it was 300 years prior, and translated that work, and then another author came across their work and translated it into yet another language. Now, the Berne Convention actually states that you are not only entitled to your translation, you're entitled to all derivative works thereafter. So every translation of your translation is actually your property. Had the second author gone back to the original work and translated it into that third language, it would not have been plagiarism, but in this case, it was considered plagiarism. There wasn't a major, sanctions or anything along those lines imposed in that case, but credit was actually given in that case. It's simply the case that it's not allowed, and that it was plagiarism, and that it did need to be addressed. The third one was interesting. The author released 2 different articles basically from the same subject material. They changed the names, so it looked like 2 different studies and etc. But it was from the same pool of data. and they quoted what should have been the second article. They cited the first article, but then the way that they were released non-chronologically, at least non-chronologically, given how they were written. It came they came to the university's attention, it was addressed, and essentially they came to the conclusion that quoting oneself is not plagiarism. It did highlight the fact that duplicate submission is detrimental to the body of works and should be avoided. The fourth one was a grant proposal. The background section was plagiarized. Why is this important? I mean, it was absolutely a case of plagiarism. It was absolutely a case of plagiarism. Why is this important? Um, the background section lets the government or whoever is providing the funding know exactly where your research is coming from and gives them an idea of the trajectory. Now, if this was completely plagiarized, which it was, they didn't check, obviously, to see if there was any sort of error or any sort of anything that should have been corrected or even updated. They didn't add additional work to it, and so it was detrimental to the trajectory of their study, and then it was also obviously an act of plagiarism. So now they cited it, but since it was a whole section taken verbatim, it was still considered an act of plagiarism. The fifth was improper citation. It wound up being deemed misconduct, but it ended in an apology only. So it was a very minor sort of. There were several. It wasn't cited properly, and so we had to go back and acknowledge that. There was a doctoral student for the sixth instance, which who used several excerpts of the valid citation. They actually went back to the magazine and found an earlier publication, and it turned out to be the magazine's problem that this was not cited properly, and not the student itself. So that was actually not an act of plagiarism. There was a very interesting instance for his seventh instance wherein a little-known theory was taken from a professor, I believe it was a professor, and it was expounded on, and an experiment was produced, and it was very similar to the, do the students get credit versus does the professor get credit discussion question that we had. And basically, the bottom line was that the theory had not been properly cited, that even though it was acknowledged, the theory belonged to the previous professor and it needed to be cited as such. The final one was not an act of plagiarism. The eighth one was a manual where it appeared that several pages had been paraphrased from a graduate student's work. They went back, and their lawyers actually got involved in this one, and they found out that it may not actually have been a paraphrase at all, that it might have just been derivative from other work. So, to recap, the reason that there are inquiries and investigations, and the reason that they pay so much attention to the rights and the protections of the initiator and the respondent is because they very often it is either not the case that something's been plagiarized, or it is the case that it's within this gray area where very little damage has been done, where it's misunderstanding, where very small adjustments can rectify the situation. So it is very important that we protect the body of knowledge, that we protect the ability to backtrack along it. But also that we protect the careers and the scientific trajectories that are produced by those careers from and during plagiarism and during the investigation.